In week 2, we talked about judicial review. This week, we're going to look at merit review and the role of administrative tribunals, in particular, the role of the Administrative Appeals Tribunal in the Commonwealth of Australia. So, in terms of key outcomes, the following are the outcomes of these this lecture video. After studying this topic, you should be able to discuss and explain the nature and function of the Administrative Appeals Tribunal. You should also be able to discuss and explain the nature and function of merits review, as well as the essential characteristics of merits review. And then you should also be able to distinguish between merits review and judicial review. So let's talk about the impetus for the merits review system in Australia. In the 1960s, as part of the post-war growth in Australia, there was a visible expansion in the size of government in Australia, and which had implications in the way that the activities and decisions of the government, of the executive government, affected the lives of Australian citizens and businesses. And this had something to do with issues of taxation or issues of licenses that needed to be secured, or issues about welfare benefits that citizens received. And therefore, the expansion of the size of the government in Australia was seen as a threat to individuals. And it was observed that there were limits to what judicial review could do. Not only was judicial review quite expensive and time-consuming, and it required, obviously, certain legal skills. It was seen that judicial review had clear limits, which we will discuss in a short while. During this time as well, at the time that the Kerr Committee report of 1971 was released, there was also a growing suspicion of the discretionary power of the executive, as well as a distrust in the executive, mainly because oftentimes decisions of the executive were based on discretion. And based on the exercise of discretion, these were oftentimes beyond the purview of judicial review. There was an awareness of a strong need for a way by which decisions made by the executive as a result of the exercise of discretionary power could actually be reviewed. And this was also at a time when, even in the US, there was a belief that many actions of government agencies were arbitrary, capricious, or involved in abuse of discretion, or were otherwise not in accordance with law. And some commentators were beginning to refer to an ever-encroaching bureaucratic society and the importance of protecting citizens against political and administrative repression. Justice Kirby of the High Court at one point said that there was a need to strike a just balance between the needs of the machinery of enlarged government on the one hand and the interests of the individual human being on the other. And as I pointed out, it was viewed that the judicial review system had its clear limitations. And at that time, there was no system which would allow review of decisions on the merits or concerning whether or not decisions were actually correct. And judicial review was inadequate because judicial review was unable to look into whether or not a decision was actually factually correct, or whether it was factually wrong, or whether or not it reflected a satisfactory exercise of administrative discretion. So these instances were beyond judicial review. And judicial review also did not permit the correction of impugned decisions by changing or substituting it with the correct one. So as a result, there was a clear need that was seen for a merits review system. And this led to the establishment in 1975 of the Administrative Appeals Tribunal, as a result of the Administrative Appeals Tribunal Act of 1975. And the Administrative Appeals Tribunal started to operate in 1976. The AAT was meant to undertake independent, informal, and non-technical review of administrative decisions made by the Australian government, particularly that of its ministers, departments, and agencies. And what's interesting is that the AAT has jurisdiction to review administrative decisions only if an act, regulation, or other legislative instrument states that the decision is subject to review by the tribunal. So in other words, the AAT on its own does not have a jurisdiction to review administrative decisions. There must be a specific act, regulation, or other legislative instrument that specifically states that an administrative decision is actually subject to review by the AAT. However, today, there must be more than 400 Commonwealth Acts and legislative instruments that actually empower the AAT to undertake administrative review of administrative decisions. As well, the bulk of the Tribunal's review workload involves applications for review of decisions in the areas of family assistance and social security, or taxation, veterans affairs, and workers' compensation as well. The AAT also reviews decisions in areas such as bankruptcy, child support, citizenship and immigration, civil aviation, corporations and financial services regulation, customs, freedom of information, industry assistance, mutual recognition of occupations, passports, and security assessments. If you'll notice, the AAT reviews a broad range of administrative decisions, but this is mainly because there is an empowering statute or regulation or other legislative instrument that enables the AAT to review administrative decisions. Now, what are the key characteristics of the AAT? The AAT provides a centralized mechanism for merits review of a range of federal administrative decisions, as well as providing people a right to have the reasons for decisions that are reviewable to actually be presented. There's an entitlement in the AAT to compel administrative agencies to provide reasons for decisions when these decisions are reviewable. In addition, the AAT constitutionally is non-judicial, and therefore it is institutionally separate from the ordinary court system. So the AAT is not part of the court system. It is not a Chapter 3 court. It is conventionally viewed as being part of the executive and part of the portfolio of the Attorney General. However, even if it may be, it is actually part of the executive government, its operations are structured around a judicial model of decision making. So to a great extent, the AAT acts judicially, and we're going to look into this in greater detail in a short while, what acting judicially really means. In addition, while the function of the AAT is essentially executive in nature, its independence and quasi-judicial characteristics make it conceptually and operationally distinct from the departments, agencies, and administrators of the executive branch. So to a great extent, it is meant to be independent of any decisions that are made by the ministers of the government, for example, or heads of agencies. So it is in fact in a position to review the very decisions made by heads of departments or agencies of the executive branch. So there is some semblance of independence. As well, the AAT is removed from the executive government's chain of responsibility. So the AAT has a unique tripartite accountability. It is accountable to Parliament through its annual reporting obligations. It is also accountable to the executive through its reliance upon operating funds and resources, and to the courts because of its susceptibility to judicial review. Another key characteristic of the AAT is that it proceeds with as little formality and technicality and with as much expedition as possible. And it is not bound by the rules of evidence, and may in fact inform itself on any matter in such manner as it thinks appropriate. In fact, it can be inquisitorial in the sense that it attempts to investigate certain matters and look for facts in order to allow it to be able to arrive at a correct decision, which is something that judicial review does not entail. Now, in terms of the membership, and we will see clearly why we could say that it is really part of the executive branch of government. In terms of the membership of the AAT, a lot of its members are not judges. And some of them happen to be lawyers, but a number of them, as we will see later on, actually are laymen with skills and expertise in other areas, whether they be in engineering or in medicine or in construction. So the AAT is composed of a president, other presidential members who may be judges or deputy presidents, senior members, and members. Now, members are appointed full-time or part-time by the Governor General. The AAT also is organized into divisions, including the General Administrative Division, a National Disability Insurance Scheme, Security Appeals, Taxation Appeals, and Veterans Appeals Division. Now, while presidential members can exercise powers in any of the tribunal's divisions, senior members and members may only exercise powers in the division or divisions to which they have been assigned. The AAT is headed by a president who must be a judge of the Federal Court of Australia under the AAT Act. Now, what does the term presidential member mean? It may refer to the president, a deputy president, or a member who is a judge. So there is an attempt on in the AAT to have a representation of judges in order to immunize it from, as much as possible, from influence by the executive government. And so those members of the AAT who happen to be judges, meaning they are part of they belong to a Chapter 3 court, they are considered to be presidential members. And as I pointed out earlier, they can exercise powers in any of the tribunal's divisions. Now, the other important thing is that while presidential members who are judges continue to hold office as a member for as long as they remain a judge, tribunal members usually hold office for a renewable period of up to 7 years. So you can see a distinction there, because whereas presidential members who are judges can continue to be in office for as long as they remain as judges, and that usually means that they can continue to serve as members of the AAT for up to the age of 70, tribunal members who are not judges only hold office for a renewable period of up to 7 years. And this means, therefore, that given the limited term of appointment of most tribunal members, if they're interested in being reappointed, then they must need to kind of curry the trust and confidence of the executive for their reappointment. And this raises questions as to their independence. And as I pointed out, many of the tribunal's members happen to be laypersons or non-lawyers who have expertise in areas such as accountancy, aviation, engineering, law, medicine, pharmacology, military affairs, public administration, and taxation. So in terms of membership, therefore, not only is the bulk of its membership not composed of judges, they're not even composed of lawyers, because many of them happen to be non-lawyers or lay persons. So there has been traditionally a lesser, although still a significant commitment to the general importance of legal expertise in the merits review process. Although, as we clearly see, the influence of laypersons or non-lawyers in the AAT is valued, mainly because the AAT is not meant to be a very legalistic system of merits review. the goal, in fact, is not about the whether or not decisions of the executive are legal or according to law, but whether or not the decisions they arrive at are something that are correct. And we examine the notion of correctness, or what is often considered as correct or preferable decision, in a short while. In addition, there has been a trend towards limited term appointments and the perceived drift away from legal membership in some regimes, which have raised concerns among those who view merits review as a necessarily independent, high status, and legalistic process. Now let's explore now the nature and function of AAT merit review. One of the key things we have to remember about the AAT merit review system is that it entails a de novo review, which essentially means it's a new review. It seeks to review from the very beginning. So, and in terms of doing the de novo review, it seeks to review across the whole gamut of facts, law, discretion, and policy. And we will remember that as far as judicial review is concerned, judicial review is limited solely to a determination of whether or not the administrative decision was according to law. In a merit review, however, the review will cut across facts, law, discretion, as well as policy. One other important characteristic of an AAT merit review is that it even seeks to consider information that was not available to the original decision maker. So in other words, if there is new information that is available after an original decision had been made, that information can still be considered by the AAT in a merits review. Equally important, the merit review enables the AAT to actually substitute its decision for that of the decision maker. Now, we will remember that the judicial review is very limited because all that the court can do in the exercise of a judicial review is actually to quash the decision of the decision maker and perhaps remit it to the original decision maker, who can then change or revise its own decision. But the courts in a judicial review are not permitted to substitute its own decision, even if it is clear to the court that the decision is wrong and that there is only one specific way by which a decision should be arrived at. So courts do not have any power to substitute their decision for that of the original decision maker. And this issue, this limitation, is now addressed by the power of the AAT, which allows the AAT to substitute its own decision for that of the decision maker, so that it arrives at a new decision. In terms of the review process, the AAT review provides opportunities for each party to appear before it and for the parties to be given a reasonable opportunity to be heard. And so this tells us that the AAT, although it is part of the executive, seeks to act judicially. And that attempt to act judicially means that it provides parties an opportunity to be heard. The AAT review process also seeks to carefully weigh the evidence and the material put before them. So in other words, the AAT does not make decisions whimsically or arbitrarily. The decisions of the AAT must be according to the evidence and the material that is put before them. The AAT also seeks to interpret and apply the law, although whatever findings or whatever decisions that the AAT may have in relation to the law, the AAT has no power to declare a law as invalid, because the power to declare a law as invalid lies solely and exclusively with the courts. So, but to an extent, if you look at the case of Brian Lawlor Automotive versus the Collector of Customs of New South Wales, the jurisprudence is clear that part of the merits review system necessarily has to involve the interpretation and application of the law. The AAT review process also exposes its reasoning processes to the parties, and it also seeks to avoid an actual bias or the appearance of bias. So again, these elements are hallmarks of judicial reviews, or the way that courts would function. And there is a clear effort on the part of the AAT also to act like a court, meaning act judicially, so that to a great extent the AAT can be perceived or can be seen as a quasi-judicial body. Now, let's look at the jurisdiction of the AAT. The AAT can only have jurisdiction if these three elements are available, and this is crucial. One is that an enactment must provide for the review by the Administrative Appeals Tribunal of the decision made under the enactment. So in other words, the AAT does not have broad jurisdiction to just review any administrative decision. The only instance when the AAT can review an administrative decision is when an enactment provides for the review by the AAT of the decision which must have been made under the enactment. And this is as a result of Section 25(1) of the Administrative Appeals Tribunal Act of 1975, which states that an enactment may provide that applications may be made to the tribunal for review of decisions made in the exercise of powers conferred by that enactment. So the AAT can exercise its review power over a decision only when specifically allowed by legislation. We will see, therefore, how different this is from a judicial review, because if you go by the common law jurisdiction of courts to undertake judicial review, it is not necessary for an enactment to specifically state that a court can actually review that decision. Under the common law jurisdiction of judicial review of the courts, it is understood that courts, as superior courts of record, retain that power to actually review decisions made by the executive. And as we pointed out, specifically under Section 75 of the Australian Constitution, there is also a constitutional basis for judicial review by the courts, because courts may actually have the power to grant the writs of mandamus, prohibition, and injunction concerning decisions made by officers of the Commonwealth Government. In addition, it is important that for the AAT to have jurisdiction, the applicant must also have standing. So in other words, the applicant must be a person whose interests are affected. And thirdly, the decision must be a reviewable decision. So in other words, not all administrative decisions are actually susceptible to review by the AAT. Among the factors that may exclude merits review would be whether or not a decision is preliminary or it's simply a procedural decision, or also whether or not it's a decision to institute proceedings, or whether or not decisions allocate a finite resource between competing applicants, or whether the decision relates to access to parliamentary or judicial records, or whether or not they involve policy decisions of a high political content, or whether or not the decision involves a law enforcement nature, and whether or not it involves financial decisions with a significant public interest element. Now, what is the scope of the AAT merits review? The merit review powers of the AAT has wide scope, as we will see from Section 43(1) of the AAT Act, which provides that for the purpose of reviewing a decision, the tribunal may exercise all the powers and discretions that are conferred by any relevant enactment on the person who made the decision, and shall make a decision in writing, affirming the decision under review, varying the decision under review, or setting aside the decision under review, and making a decision in substitution for the decision so set aside, or remitting the matter for reconsideration in accordance with any directions or recommendations of the tribunal. We will notice, therefore, at least two things. One, the AAT has the power to vary the decision under review. A judicial review, the courts, in exercising their powers of judicial review, do not have any power to vary a decision of the executive. The AAT, however, has a power to vary the decision under review. But more importantly, the AAT also has a power to make a decision in substitution for the decision so set aside. Judicial review cannot involve a substitution by the courts of its own decision for that of the executive. That is not permissible, because to a great extent, if that were to be allowed, it would be as if the court is a super body or a higher body that actually has oversight over the correctness of the decisions made by the executive. So judicial review is limited in the sense that courts are only able to examine whether or not a decision of the executive is according to law. But courts do not have any power to substitute its decision for that of the original decision maker. The Administrative Appeals Tribunal, however, has the power to substitute its own decision for that of the original decision maker. Now, in terms of the scope of the AAT merits review, there are some key observations that we can make. As I pointed out, the AAT has broad powers, so it can affirm or vary the decision, or it can set aside the decision and either make a substitute decision or remit the decision for reconsideration by the decision maker with directions which are binding or recommendations which are non-binding. In addition, Section 43(6) of the AAT Act provides that when the AAT varies a decision or makes a substitute decision, the AAT's decision is deemed to be a decision of the original decision maker, as from the date of coming into effect of the original decision. Section 43(1) also provides that in reviewing the decision, the AAT may exercise all the powers and discretions that are conferred by any relevant enactment on the person who made the decision. This has the effect of enabling the AAT to stand in the shoes of the original decision maker. In contrast, the task of a court exercising administrative judicial review is to police the limits of decision-making power. And certainly courts cannot stand in the shoes of the original decision maker, and neither can the courts exercise the discretions that are conferred in the original decision maker. Now, one thing that we will often hear is that in terms of the merits review, the role of the merits review system is to determine whether a decision under review is the correct or preferable decision. In Drake versus Minister for Immigration and Ethnic Affairs, Chief Justice Bowen and Justice Dean stated that the question for the determination of the tribunal is not whether the decision which the decision maker made was the correct or preferable one on the material before him, the question for the determination of the tribunal is whether that decision was the correct or preferable one on the material before the tribunal. In Shi versus Migration Agents Registration Authority, Justice Kiefel in the High Court of Australia elaborated on the notion of the correct or preferable decision. She said that the object of the review undertaken by the tribunal has been said to determine what is the correct or preferable decision. Preferable is apt to refer to a decision which involves discretionary considerations. So this means, therefore, that there is some latitude as to what the decision should be, depending on the exercise of discretion according to discretionary considerations. A correct decision, however, in the context of review, might be taken to be one rightly made in the proper sense. So in other words, when you speak of a correct decision, you're speaking of one decision that should be the decision that should be arrived at in the context of the review. And it is inevitably a decision by the original decision maker with which the tribunal agrees. Hence, correct is taken to mean where there is only one acceptable decision, and preferable refers to situations where it considers there to be more than one acceptable decision. So after this lecture video, you should be able to discuss and explain the nature and function of the Administrative Appeals Tribunal. Should also be able to discuss and explain the nature and functions of merit review, as well as its essential characteristics, and be able to distinguish between merits review and judicial review.